Okay, so this is my disclaimer. So as you all can see, okay, so I've shared the record, share the screen already. So okay, so this is a disclaimer because I am still not a qualified person yet. Whatever answer or suggestion during the session should not be deemed as a final or definitive answer. Okay, so whatever, so that the answers we are giving here is just for the referencing or for your to enhance your learning purposes only. It's not like the standard answer given by any markers from the qualified board lah, because until today we still don't have any standard answer given by them. Okay, so to understand the civil procedure, the main objective is we have to understand. Oh, sorry, you can't see my screen now. Okay, never mind. Let me share again. Okay, can anyone see? Can everyone see now? Okay, so to understand the civil procedure, the first thing is we have to understand the process of the civil litigation in Malaysia and jurisdiction of each court in Malaysia and the relevant principle governed by every single civil action. So the the exam time in for the civil procedure is you'll be given 3 hours to answer 4 questions out of the 8 questions. So the questions will be divided into 2 parts. Part A is the compulsory, you cannot skip. Then the part B, you have to choose 3 questions out of 5 questions. So to take this one, I think I will share it later. I will share it when we are doing our revision lah. Okay, so the first chapter is preliminary matter. So for the beginning of the civil procedure, right? What we have to be familiarized is the governing statutes. So the governing statutes using most of the time is Subcourts Act 1948, CJA 1964. The difference between these two acts is the Subordinate Courts Act is governing the subordinate court like Magistrate Court and the Sessions Court, while the CJA is governing the High Courts only. So another one is Limitation Act, Civil Law Act, and we will discuss and discover or explore it further in our classes. So along our study, you have to be very, very frank with your rules of court 2012 because we'll be using that very frequently. However, for the rules of court of appeal, rules of federal court, we will only touch it in certain chapters lah, not in most of the chapters. Okay, so the first thing is under the what falls under the preliminary matters is first thing, overriding principle. So the overriding principle is where sorry, I see someone joining. Okay. Okay, so the overriding principle is that when you did something wrong, that doesn't mean that your trial will be thrown out. It's like one case lah. You cannot simply say that, oh, right now I did something wrong, and then my case thrown out. The overriding principle is a considering factor under the court's discretion whether or not your non-compliance is fatal to your case, so that the case on point is Megat Najmuddin Dato Seri Megat Khas, so that it could be found in Order 1A, Rules of Court 20 and 12. Sorry, because I've forgotten to screenshot. Does any one of you have the Rules of Court with you? Okay, so if any one of you have the rules of court, can you please flip to Order 1A of the rules of court, please? So when you see the rules of Order 1A, right, you will see this. The court or a judge shall have regard to the overriding interest of justice and not only to the technical non-compliance with this rule. Do you all see that? Okay, so that means the irregularities of the during the trial will not it's not necessary to invalidate or nullify a proceeding, so that it is subject to the extent or the seriousness of your non-compliance. So the difference between the irregularities can be divided into non-compliance of jurisdiction matters and technical non-compliance. So we will discuss jurisdiction matter. The jurisdiction matter means that you already breached to the you already non-complied to the jurisdiction matter lah. So that means it's a very serious non-compliance. That means your case will be thrown out by the court lah. So the first thing is you don't have the local standard. The local standard means that because when we are in the court, right, you must make sure yourself you have a local standard, which means that you are the right person. You are having a capacity to bring an action, or you can be sued by another person. So without local standard means you are entering into the you are bringing this action as a joker lah. So it means that you are a nobody, but you don't know why you are bringing this action and you don't know why you are being sued. So that this will cause your case being thrown out by the court. Is everyone clear for this? Okay. So the case on point is Government of Malaysia and Lim Kit Siang. So every time I think most of us are struggling whether we should memorize for both sides or even one side. Actually, to be honest, one side is good enough already because we have a lot of cases to memorize. So that I think either side will be enough lah. But since this case is Government of Malaysia and Government of Malaysia, I'm pretty sure there are a lot of cases lah. So either you can just like putting Lim Kit Siang will be enough. Okay, the second issue is fail to renew the rate because you can see from here the application to renew a rate must make before the expiry of the rate. So that means if you fail to do so, you never comply to the law, right? So your case will be thrown out. Are you all okay with this? So the rule will be Order 6, Rule 7, 2A of the Rules of Court. Then the third one will be non-compliance of service of writ to individual. As you can see, I have highlighted the word shall. The shall doesn't matter whichever your criminal procedure code, your whatever act as well. When you see the word shall, it denotes a meaning which is more seriousness already because the word shall has a higher standard than must. So it's a mandatory requirement. So when you see the word shall, if you never comply, it's very dangerous one. Are you okay with this? Okay, so the fourth one is non-compliance of the requirement for summary judgment. So for the summary judgment, I think we will discover it soon or later, but just a brief idea for every one of y'all. Summary judgment is you want to dispose a matter without going for full trial. When the plaintiff served a writ and the statement of claim to the defendant, provided that if the defendant does not have any defense, the plaintiff can apply to the court for the summary judgment, and we will discuss the type of the summary judgment soon or later lah. So the next one will be judgment in default entered irregularly. So the JID is that when you already serve your writ and the statement of claim to the defendant will be given a certain time frame. During the certain time frame, when the defendant has failed to enter into appearance, then the judgment in default can be entered by the plaintiff. So it simply means that the defendant is already surrendered himself to defend. It's like surrendering already because you are given the certain time to enter into an appearance to defend your case, but you fail to do so, so that the judgment in default can be entered against the defendant. But however, if the judgment in default is irregularly entered, it can be struck out by the court. And one more point, the JID itself is not a final judgment. It can be set aside within 30 days. And I will cover this later. Now, we come to another type of the technical non-compliance, which is a curable and the trial will not be nullified. So the first thing is conversion of OS to a writ action. So for everyone's knowledge, OS is originating summon. So the originating summon is that you will start your case by using the originating summon together with your affidavit in support to support your it means that during the entire process, both parties are just exchanging the affidavits. Affidavit itself is a sworn statement by yourself to the court, because you cannot go inside the courtroom and say, oh, yeah, Arif, I want to say this and that. You cannot, because we don't have the locus in the court itself, so that this is the only paper that we can say whatever we want. Together with the evidence, we tell to the court what are we going to say. So the conversion of the action, the case on point is Ting Ling Q, and the order is 28 Rule 8. You can see from here. Okay, I will share the slide to everyone in the group later. So you see, another type of the technical non-compliance is that amendment of pleading. What does it mean by the pleading is that when you serve the writ together with the statement of claim, the statement of claim itself is a pleading already. So for this is because in the end, after the end of exchanging the pleading, we have to file a bundle of pleading to the court, so that the pleadings, the type of the pleadings we will also discuss and explore it further. But just for your knowledge, the technical non-compliance, amendment of pleadings is covered under technical non-compliance, which is curable, because sometimes reasonable. Today, I written a wrong name. Instead of calling Dr. Chi, I'm calling him as Dr. He, so that I want to amend his name. Yes, it is allowed with the leave of court. So if you want to see, I think is order 20 Rule 5 sub 2 or 3. I am not very sure, but it's either one of them. So another one is amendment of judgment due to slip rule. The slip rule, it means a clerical error, so that when the judgment at the end of the trial and everything is completed already, the judge will give a judgment. So when you see the judgment has a certain error, like from 1.5 become 1.4, then you can apply to the court to amend the judgment. It will not invalidate the trial, and you can apply for the amendment. Okay. Okay, I saw a question here. Does it mean that anything not mentioned in the affidavit cannot be mentioned in the court? Let me think about it first. I think the logic is here. I think the logic is here. When you say something in your affidavit, of of course there is a reply to your affidavit, so that you can add on your thing in the affidavit in the later. So it doesn't mean that your every OS action has only one affidavit, because the affidavit has pretty much lah, since it's exchanging ma, so that now I say this, later on you want to add this to object my, you want to use it as your objection or denial to my prayer, you can raise that, substantiate with your evidence only. Is that okay, Cindy? Okay, good. So we move on to another one, the preliminary objection. What does it mean by the preliminary objection? Like today, you sue a person, then the person raise the objection to the court, just want to throw your case on it. Okay, so that according to Order 2, Rule 3, the court shall not allow any preliminary objection unless there is a substantial miscarriage of justice. Because you cannot simply go to the court and say that, hey, Yang Arif, I bossong this further for so long already. Now I want to throw his case. This is my preliminary objection. You cannot, because you have to substantiate with your applicable law, like let's say the limitation period, and then or whatever irregularities they have done, you have to substantiate with a reasonable ground. So in the case of Bukit Melita Sdn Bhd, if any party wishes to raise a preliminary objection, you must serve a written notice as early as possible. Otherwise, it's amounting to waiver of right. So if you want to discover how long is the time frame, right? Okay, this is the time frame given under Bar Council ruling chapter 11 and rule 4. Not later than 4 clear working days before the hearing day. So that if you fail to do so, then you cannot raise the preliminary objection already. So what are the examples? First thing is limitation period, as I mentioned, and your whole suit is groundless. Okay, cause of action. Cause of action, using a layman term, is the ground to file the action. So how does the case laws define the wording of cause of action? The first UK case is Cook and Gill. The definition of cause of action is that every facts necessary for the plaintiff to prove and entitle him to succeed. And the leading case in Malaysia is Lim Kian and Chu Kun. So in this case, the definition of the cause of action is that there is a plaintiff to sue, a defendant to be sued, and the material facts entitle plaintiff to succeed. Okay? Okay, so what is covered under the cause of action? The first thing is locus standi, whether the person has the right to sue or to be sued. Second thing is the limitation period. So in every single action, you will see the limitation period, because this is to make sure that your action is still valid. So as you can see, from Section 6 sub 1 of the Limitation Act 1953, 6 years from the date of accrual for a tortious action. I am sure that in your general paper, you all have been touching CLA for quite common, right? Because CLA used to, you all might be quite oftenly using CLA or the CLA for the when you are preparing your top paper, right? Under the general paper. Okay. So the same logic applies here. When you see Limitation Act, for tortious action, like as we can see, the motor vehicle accident, breach of contract, 6 years from the date of accrual. And then another one is the enforcement of a judgment. So to enforce a judgment, right, when the court gave you a seal judgment together with the lion, with the tiger mark, you have 12 years to enforce. But one thing, if you fail to enforce the judgment after the 6 years, you have to apply to the court for the leave of court, which means that, oh, now you're telling the court, I fail to enforce the judgment within the 6 years. So I want to use another 6 years to enforce the judgment, and you have to show your good reason. And then a very main point, a very important point is you are not entitled for the interest. Okay, another one is recovery of land is 12 years. So I have screenshot the section. Okay. Okay. So another limitation, as we can see, is Section 2 of the Public Authorities Protection Act 1948. Actually, I can put it as PA lah. Just a short form only lah. Yeah. So for this action, right, for if you want to sue a government, right, 36 months only. So I have highlighted within 36 months after the act, neglect or default complaint. Okay, let's see let's see our friendly section. The Civil Law Act 1956. 3 years is the limitation for you to bring any dependency claim. So the dependency claim is that when anyone died, and then you are bringing the action in the capacity of their children or whatever else, you have only 3 years from the date. Okay, you see, after the death of the deceased. Okay, so this is the case on point, Guan Hit Ping. In this case, the court, the federal court, dismissed the claim as it was 4 days later after the limitation period. So that in every single civil action, right, limitation is very, very important. If you fail to do so, even 1 day is considered too late already. However, there are some exceptions. The first exception is the fresh accrual of the action from the date of acknowledgement, which means that, as what we said in the Section 6 of the Limitation Act, right, you are given 6 years. But what if after the 6 years, you only discovered the fact, how was it happen? So that this is the first exception as per Section 26 of your Limitation Act 1953. The fresh accrual of action is the extension of your Limitation Act already. Then the second one is fraud or mistake. So fraud, for everyone's information, the fraud I'm saying here is not a criminal fraud. It can be a civil fraud. So that means when somebody, let's say right now I'm giving you a check, but the check doesn't exist in the first place, then I use it as an evidence. This is a fraudulent evidence. So when you discover this is a fraudulent thing, and then your limitation will run from the day you discover it, as you can see from here. Okay, the third one is end of disability. So the disability we are discussing here is, first thing, there are two categories of disability. First thing, the first category is minor, who is younger than 16. We will cover that soon. And then another one is the mental patient. So that means end of disability means when this period already end, then only the limitation period starts. It's an extension lah. Okay, I have covered for first chapter already. Anybody have any question to ask for the first chapter? Okay, no question means I can proceed already. Recently, Malaysia bar sued AG for dropping. No, 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 no. For this, when Malaysia bar sues AG for dropping the Zahid's case, actually, it's a very interesting question because I think you have studied in your criminal procedure code, right? The AG is given the power to either withdraw the case or initiate the case. I think it's under Article 145, sub 3 of your federal constitution. It's their discretion. If you want to sue them, very interesting, this one. Let me check and then I will answer to you. Okay? Okay, now it comes to jurisdiction of the court. In Malaysia, the hierarchy of the court is categorized into magistrate court, the lowest court in Malaysia. Then second one will be the sessions court and high court, and also the appellate court like court of appeal and federal court. And each court has their own jurisdiction governing the civil matters lah. So these two are, as we already discussed, MC and SC are the subordinate courts, and three of them are the appellate court already because they have the appellate jurisdiction. So the magistrate court is divided into first and second class. So for the second class magistrate court, your monetary limit is up to 10,000 only. This is provided in your section 92 of your Subordinate Courts Act 1948. And another one is small claim. The small claim in the magistrate court means when you are owing a person certain sum, you no need to hire a lawyer. You just need to the court and then you just fill up the form and then the magistrate court will issue a summon for him, will issue a paper for the person, your debtor, provided that your everything is documented lah. So the person will be called to the court, and then the magistrate will ask him, hey, kawan, you hutang orang this is the small claim because it doesn't involve any lawyer. And some more 5,000, I don't think so enough to pay a lawyer fee lah. Then the first class magistrate court, the monetary limit is up to 100,000. So this is provided in your section 90 of your Subcourts Act 1948. And then, however, there are certain exceptions. The first is agreement by both parties. So let's say today you are going to claim more than 100,000, then you all decide lah because you want to cut costs so you think 100,000 is quite you all are agreed to file the action in the magistrate court because you want to get a cheaper court filing fee, so you all decided. So because this is the monetary limit until 100,000, so in the end if you're claiming more than 100,000, then you write and agree by both parties okay, we accept. So it's okay. So the second exception is interest accumulated, which means because in the end of the day, the judgment will provide certain things. The one of the prayer is that the interest I think is 5 or 8% per annum. Yes. That is one. Then the third one is relinquishment. Relinquishment is that now everything sum up is more than 100,000 already. So you all agree that 100,000 is the final claim for everyone, both plaintiff and the defendant. So this is the third exception. Now we can move to sessions court already. Sessions court, you see, monetary limit is up to 1 million. So this is provided under section 65 Sub 1 and Sub B of the Subcourts Act 1948. So what is governed under Sessions Court or the Sessions Court jurisdictions? First thing is rescission of contract. This is provided under Section 65 1C of your Subcourts Act. Then the injunction and make declaration. Then grant the relief by interpleader. However, there are certain exceptions. The first exception is motor vehicle accident. You have unlimited monetary jurisdiction. So that I am not sure whether your lecturer during your GP days already. I think if you all notice, past few years when we are doing the statement of claim for the tort, right? We are filing the action in Sessions Court because under Section 65 1A of the SCA 1948, Sessions Court has the unlimited monetary jurisdiction for motor vehicle accident. So that no matter your claim is more than 1 million or 2 million, you can still file in the Sessions Court. Then the second, third, and the fourth one is same as your magistrate court. So, okay. So on a side note, they have no jurisdiction over the matters. The first thing is bankruptcy and winding up, divorce, grant of representation, which means the probate action. The fourth thing is enforcement of trust, accounts, and dispute of title for immovable property. So when it comes to any one of these matter, it should be filed in the High Court. Okay, coming to High Court, right? There are two High Courts in Malaysia. It's pretty important because when I was working in law firm, right? My interviewer asked me, the first question from my interviewer is, he asked me, how many High Courts in Malaysia? If I tell him more than two, I think he will laugh at me. Because in High Court in Malaysia are divided into High Court of Malaya and High Court of Sabah and Sarawak, which is for the East Malaysia. This is provided in Article 121, Sub 1 of the Federal Constitution. And in a technical sense, the High Court of Malaya could be different for certain rules. Is applicable to West Malaysia and not applicable in East Malaysia. We will discuss it later. So the subject matter, they can try all actions. And monetary limit, no limit because High Court already. Okay, now the question is whether a proceeding can be transferred. Okay, so this is provided in your Order 57, Rule 1 of your Rules of Court 2012. The court may order the proceeding to be transferred to a higher or lower court up on the application. So this I have already screenshot, as you can see. But one thing, you cannot transfer the court from the High Court of Malaya to High Court of Sabah and Sarawak because there are two different courts. So that it means right now your matter actually happens in Kuala Lumpur. But now because one of the party is living in other state like Kelantan, Kedah, Johor, then for the convenience of the parties, you all can transfer the matter from KL to the states under West Malaysia, but not to East Malaysia. Is that clear? Okay, so for you to answer when the question asks whether you can transfer a case or not, you have to see what are the criteria. So for subcourts, is Section 2 of the third schedule of your Subordinate Courts Act or S99A of your Subcourts Act 1948. If High Courts is under section 23 sub 1 of your CJA 1964. But the logic are but the criteria are the same lah. First thing you have to see, where did the cause of action arose? Let's say today, or in the motor vehicle accident, it takes place in KL. Then you can choose to file in the KL. And where the defendant resides or having a place of business, which means that the defendant is living at this state or in other state, you can choose either one of them. Then facts of the proceeding base exists. I think it's more or less same, these two. So this is the case on point. Sova Sendirian Berhad, doctrine of convenience is for the defendant to apply for transfer the case where he resides. So the court will depends now. Sometimes if you want to file the case or you want to transfer the case, right, you have to subject to the place where does the defendant or most of the defendants reside, living at that place or having a business at there, because you want to serve the documents easier. Okay, I think we have finished chapter 2. Are we all clear on chapter 2? Back to accept. Okay, I saw Cindy's question. Is the case is okay, first class of MC. Is the case still tried in MC or in sessions court? Okay, let me check again. 65 sub 3. Okay, you are talking about the agreement by both parties, right? Okay, so actually it's still tried in the magistrate court, just that you can claim more than, let's say right now you are claiming after adding on whatever cost is more than 101 already, more than 100,000 already. So if you want to still proceed in magistrate court, you just agreed by both parties. Okay, so let's say plaintiff and defendants, they are already agreed into whatever surplus more than 100,000, we accept for it. Is that clear for you? Okay. Now we can come to the chapter 3, mode of commencement. Okay. So what happened? Okay, I saw another question. So what happened if, example, D from Kedah, cause of action in Penang, where to try the case? Okay, Sundaragana. Okay, I think, okay, when you ask me this question, right? Okay, let me tell you something. It is very oftenly happen and common. So it's up to you. You want to file in Penang, it's okay. If you want to file in Kedah, it's also okay. Because as long as you already satisfy the criteria, you can. It's up to your choice. Maybe soon or later, I think maybe I can try to share the past year questions, because it used to ask in the past year questions for the recent year. I think if you want to see, right, I think you can try to look at the compulsory question for main sitting and the conditional sitting last year, which is 20 and 23. So you will see the compulsory question that always will mix up one. Cause of action in this state, and then the defendants are in another states. So it's up to you whether you want to file in this court or you want to file in that court. It's up to you, because since you already fulfill the criteria. Yeah, answer to your question, Sundaragana. Okay. Okay, we can move on to the mode of commencement already. In every single civil actions, right, there are two modes of commencement, which is originating summons, as I said earlier, is the OS. Another one is the writ action. So OS, there's no need for trial. There is just exchange on the affidavits, and then it's faster and cheaper. Okay, and then how do you determine whether you want to initiate your action by OS or writ? The first thing is whether this is point of law. Okay, so the first thing is, does anyone of you still everyone is clear what is the difference between question of law and question of fact first, before because this will be very frequently asking in the you have to think it when you are answering the question on what type of the commencement for that action you are intending. So does anyone know what is the difference between question of law and question of fact? If you know, then if you need my explanation, you can type on the chat box, yeah. Because throughout the subject, we will keep using it quite frequent. Question of law and question of fact. Okay, so the question question of law. Since Dr. Chi is not here, then I can use him as example already. Okay, question of law is that I will give you a situation. Let's say right now in a very public occasion, I call Dr. Chi as, hey, Dr. Chi, stupid ah. Then he sue me for defamation already. So when it comes to question of law, you are going to determine whether the word idiot has a defamatory meaning. So from another point of view is that if you are looking at the question of fact is whether I have said this word. So did I differentiate between question of law and question of fact? Okay, so applicable for point of law is like the interpretation of law, whether the thing is done correctly or accordance with the law. So it can be converted into read action, and it is curable irregularity. I think we have covered this in our chapter 1 when we talk about the preliminary objection, because sometimes you know lah, when people don't know, then they start the OS action, but turns out there are a lot of evidence, and it is ought to be a full trial so that the court can convert the OS action into a read action. This can be seen in Order 28 Rule 8 and the case Ting Ling Q. So this is the sample of OS. Okay, for everyone's knowledge, actually this one is one of the example. So the title here, we didn't call them as title. We call it as entitlement. I will type in the chat box how to spell it. So the entitlement will cover dalam Mahkamah Tinggi Malaya di Kuala Lumpur. Okay, so you can see here in the High Court of Malaya, and then in which particular state, and then saman permula number. Okay. Then the next one is read action, where there is a substantial dispute to facts. It means that now this is the version from the plaintiff. Then another version of story from the defendant. This is so-called a dispute as to facts, because you have to decide whether this was taken place or happened already. So this is the dispute to facts. Like in real life case, just as I'm using the case just now. Now Dr. Chi sue me for defamation already because I call him as idiot in the public occasion. Now I must defend myself, and I say, hey, I never say that. I never say that. Takkan I go into court? I have said it. So what? It's impossible, right? So when it comes to dispute to facts, you must use a read action already. So the feature of the read action is it will include the pleadings. The type of pleadings, we will cover it in the later chapters lah. Then in the read action, the court will fix for a full trial, and it's a very lengthy process because throughout. But one thing, I think there is a KPI given by the court already. Within a certain time frame, you have to close one case already. Otherwise, it's just like what we used to say, a full trial, a court case takes you more than years. So there is a KPI for them to finish a case already. So for your understanding, I have a sample of rate in this slide. So as you can see, this is your case number. Your case number will subject to the state. So since this is a KL court case, so it's same as your car plate number lah. It's starting from W. A is fixed one. So this is your case, the how do I say the type of the case to be filed. Then this is your case number lor. This is the year. So this is the entitlement dalam mahkamah blah 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 blah. And then you will see the enclosure number. The enclosure number is given by the court. Actually, the enclosure number is what are the how many documents you have filed into the court. So enclosure number one means this is the first document you file into the court. So antara this plaintiff and defendant, the writ. Okay. If you all have practiced, if you all have been working in the law firm for litigation, writ for nowadays, because we are using the e-filing portal, so that to fill up the writ, right, actually is using the e-form. So you just need to fill up the details, like filling the blanks on this, so that up on filing the writ, you must together with your statement of claim. Okay, I think I have covered 3 chapters for today already. So may I know if there's anything you all want to ask? Because the reason I've allocated 1.5 hours is I I want to make sure that during our class we are given sufficient time for everyone who wants to ask the question, because I am pretty sure that there are some people who wants to ask the question. I hope that the extra time I'm giving is enough for you to ask the question. So if you want to ask question, you can type in your chat box and I will reply accordingly. Anyone? In addition, foreign conveniences, I think I have. Okay, maybe I never explained it clearly, so sorry, I'm Sandeep. So the forum of convenience actually in this case, right, the doctrine of convenience is for the defendant to apply for the transfer of case where he resides, which means that the defendant has the upper hand to choose on which court he wants to maybe let I think one of the question from the chat box is that the cause of action in okay, the cause of action takes place in Kedah, in Penang, but the defendant is living in Kedah. So the defendant can apply to transfer the case from Penang to Kedah. Did I answer your question? Okay. So apart from Sandeep, may I ask if anyone has question to the chapters we already covered? Okay, maybe I try to share some partial question to answer the question for the doctrine of convenience. Okay, just give me a few minutes because I'm trying to find the partial question. Now you see, this is the one of the question from last year. Abu signed the agreement in Kota Baru, Kelantan, and the register at with TAS, and the TAS has its register address at KL. So so you see, course of action is to supply the thing in Kelantan, but you see the defendant has the register address at Kuala Lumpur. Then you see the question number one. You see, the question we're asking like this: in which court and where should the legal action to be commenced? So you see, to answer the question is like, okay, so we already identified these parties. You see, another fact is TAS has appointed an agent who resides in Kota Baru, Kelantan. So that to answer the question, the answer is you can either file the case in the Kuala Lumpur court or in the Kelantan court, because it fulfills the criteria, right? Cause of action taken place, and then place of defendant resides or having a place of business. So you see, taking a place of business is Kelantan already, because to source the material and arrange transportation Then the registered address is at Kuala Lumpur. However, the course of action is to supply material to his factory at Kelantan as well, so that you can either file the action in KL High Court or in the KL Court or in the Kelantan Court. Is that clear for everyone? Okay, apart from the questions, right? Does any one of you has any question to raise? Does OS strictly? Yes, yes. You, because in the OS, right? What you are going to give in your affidavit is the affidavit is your evidence. You only plead your evidence, or plead the or you are giving the evidence and your explanation only. It doesn't, since it's not a full trial, there's no need for a witness. Question of law only, because you are not disputing to the facts, ma. Okay. Anyone has questions? But never mind, maybe today is the first, this is the first class, so I will only cover the first three chapters, because I also want to know where did your civil procedure stop at? It's like until which chapter you all already covered. So if for the next class, I want to ensure that I won't moving that faster than your lecture. So can anyone share with me where did your lecture stop at? I am not attending so we did enforcement of judgment and cover C the last year paper. Enforcement of judgment. Oh, which means it's quite behind already. Which means, Cindy, so you are saying that your lecture is almost finished the subject already, right? I think they didn't go chapter by chapter. Oh, like that also quite okay. Because I'm covering chapter by the reason why I'm covering chapter by chapter is because the first thing is I have to and because I'm going to because the thing is uh for the benefit of the civil procedure, right, it's not that mixed up compared to the to other subjects. So the first thing is there are so many topics and so many areas. So each question will be allocated for I think one sub question will be related to one chapter only. So that since they are interrelated, I hope that I won't skip any chapter lah. So that is the reason why I keep on asking this. Okay, so is that okay if we end this session? If there's no other, if there's no other question from you all, may I know how often inherent powers of the court? This one, Order 92, Rule 4. Let me check. I think you are referring to some appellate jurisdiction of the court, right? For the inherent powers of the court is to review the judgment and to prevent injustice. But this is not that really often. Because sometimes how do you justify whether there's a miscarriage of justice? That is the first question. The second question is on whose application? Usually must be the appellant, right? When you are going to use this. Yeah, that's why most of the time the inherent power uh, is subject to the court's discretion whether they want to use it or not. But you have to make a distinction between the inherent power exercised by the court and the appellate power. Appellate power is your judgment is a final judgment, and then you dissatisfy, so that is the reason why you go for appeal. But the inherent is whether the court want to take the initiative to use the power so that it doesn't take it for granted. So when the only until the court realize, oh, I think this is not fair, then I try to use my inherent power to review the decision. Did I answer your question? Okay, so for everyone's knowledge, for everyone's information, the reason why I am helping Dr. Chi on this, is because I feel so glad that I have joined the pro bono class because during my time, my sitting was at 20 and 19, and then last year was my final attempt. So I met Dr. Chi on my final attempt, and very thanks for his help. I have passed my CLP on last year conditionally. So actually, and also I have voluntary to tell Dr. Chi that I will be joining this. I will be helping him because I have secured my civil procedure paper in my first three attempts, except for the last one. So I already identified how to answer the question. So throughout our sessions in future, I will try to guide you all like how to identify the questions by looking at the so-called keyword. And then you all will know, oh, when you see the particular magic word, it's related to which chapter already. So that if anything you all want to ask, feel free to call me, and this is my phone number, and I will share this slide in the group later. So if there's no answers from here, I think I would have to stop at here, and then I will see you all in the next session. Does everyone still have some questions to ask before I close this section? Okay, thank you for everyone joining our very first civil procedure class. I will see you all in the next session. Okay, so last but not least, anything you all want to ask, just text me and not call me lah, because I'm also a working person, so that when I'm working, I may not able to attend to your call. So anything, just text me and I will reply to you as much as I could. Okay, I will see you all in the next session. Good night and goodbye to everyone. See you all.